Findling with Findling Law and thedivorceguy.com, and this is the Divorce Education Series. And today we're going to discuss and explore and examine alimony in Michigan. It can be a very complicated subject. We're going to try to break it down for you, make it easy for you to understand, and hopefully provide you comfort in your situation. Let's get started. Alimony in Michigan, what is it? They're periodic payments to a former spouse for his or her maintenance. It literally is support, spousal support. And as you can see on the slide, spousal support and alimony are synonymous. They mean the same thing. If someone mentions spousal support, they're talking about alimony, and vice versa. One of the most basic and fundamental tenets of the law is the ability to point to the power. So when it comes to the statutory authority for spousal support, we look at Michigan Compiled Laws 552.23, and it provides that spousal support shall be granted when it's just and reasonable. And oftentimes the law gives us these vague and ambiguous terms. What does just and reasonable mean? Or after consideration of all the circumstances of the case. So in the next slide, we're going to examine exactly what this means and how a court goes about determining whether alimony or a payment from a primary wage earner to a dependent spouse is appropriate and under what circumstances. So in exploring some of these terms, these vague terms like just and appropriate, or in this case, all of the other circumstances of the case, we look at case law. And one of the seminal cases is called Berger versus Burg, but it really doesn't tell us much until we get into a little bit more detail. Berger says that the primary purpose of spousal support is to balance the income of the parties. Now that may mean equal to some people or equalize the income of the parties, or balance that is just and what is fair. And Berger also points to this notion of circumstances of the case as well. Well, in order to understand what that means and how a court determines how spousal support is awarded, we look a little further and we find that there are factors. Let's examine them. So the Berger case and subsequent cases as well outline 14 factors. And what are they? Well, they're on the screen here and we'll summarize them. The past relations and conduct of the parties really talks about fault. Did one person's conduct, was that a basis for the breakdown of this marriage? And would it be equitable or fair or just and appropriate to award spousal support to the other party because of his or her conduct? Obviously, the longer the marriage, the more likely that spousal support would be awarded. In addition, the income of the parties, often described as the abilities of the party to work, is relevant. If somebody chooses not to work, but they're capable of making a substantial sum, even if the other party is making more money, alimony award may not be just and appropriate under the circumstances. Of course, we look at the source and the amount of property awarded to the parties. For example, are there income-producing assets? Did a spouse receive so much in terms of property that alimony isn't necessary? The older an individual is, the more likely they may need alimony, or the more likely that the court would say, no, you're retired. Alimony should not be paid. Rather, you should rely on your own retirement or Social Security. The ability of the parties to pay spousal support in the present situation of the parties doesn't really provide us significant insight as to what a court is looking at. But I think from a general perspective, we have to take a step back and say, okay, under these circumstances, is alimony appropriate? And I remember being at a lecture once with the Court of Appeals judge that said the law is equities or fairness controlled by statute. So what we're seeing here with these alimony or spousal support factors is exactly that. The court trying to provide guidance as to equity, as to what is fair. Let's examine the balance of the factors. Well, one of the most important and relevant subjective factors would be factor number 8, which are the needs of the parties. Do the needs of the parties require or demand that alimony be awarded? The party's health, certainly goes to the ability of the parties to work. The prior standard of living is related to the needs in many ways. Are you living at a lifestyle and exposed to a lifestyle that just pulling the rug from under you wouldn't be just inappropriate under the circumstances? The contribution of the parties to the joint estate. Did both parties work during the marriage? Fault in the past relations and conduct are overlapping in many ways. Did a party have an affair? Is he or she now cohabitating with another individual? Is his or her expenses reduced as a result of that cohabitation? May have an impact as to whether or not alimony would be awarded. And when we talk about general principles of equity, it's sort of a catch-all provision that says anything else the court might consider fair and just, which is what equity means under the circumstances. Now, I've entitled this slide the real factors, and the first four are what comprise the majority of alimony guidelines, which we're going to discuss in just a minute. The age of the parties, the income of the parties, the length of the parties' marriage, and the education of the parties are objective variables. They're numbers that we can place into a computer. And the alimony guidelines look at those factors. Why? Because they're easy to plug into a computer. And probably the only other factor that tempers these four objective factors when it comes to settlement are the needs of the parties. That is, are there special circumstances or needs of the parties that suggest that we just can't look at these objective variables? Maybe an individual is caring for an adult relative or child that increases the expenses of the family. Or maybe a party has excessive healthcare expenses because he or she is recovering from cancer and his or her needs are much larger than, let's say, the average individual. But I call these the real factors for a reason. When we focus on alimony in negotiations or at trial, these are the variables. Of course, there are 14 factors, 14 variables that a court must consider, but if we can narrow them down to 5, these would be the 5 that I would narrow them down to. So I want to explore this notion with you about guidelines. And there's some cases that sort of contradict each other, which isn't uncommon in the law. The Milan case says that it's improper for a court to adhere to a strict and rigid formula regarding alimony. The Gossett case says guidelines are okay provided the court makes the findings about all of these other factors, these 14 factors that we discussed. And why is this important? Well, every lawyer who practices divorce law, every mediator, and every judge has guidelines in his or her office. We use them on a regular basis to try to provide insight, to try to give us guidance of what an alimony award should be. And then we move from guidelines if necessary with creative lawyering, whether it be a higher alimony award or a lower alimony award, as the circumstances or the needs of the parties and applying the other factors apply. Now, because the majority of cases settle, when settling a case, a mediator is always going to use guidelines. They're going to look at guidelines and say, okay, and then maybe make a recommendation tweaking one way or the other. So this is going to require us to examine exactly what are guidelines. Let's take a look. All right, when it comes to alimony guidelines, it's important to understand there are no official alimony guidelines. While there are for child support, the Michigan Child Support Formula Manual provides a specific formulatic approach for calculating child support that parties must follow. No such guidelines exist for alimony. Rather, you have to examine the 14 factors that we talked about. But that doesn't mean there are not alimony guidelines. In fact, Craig Ross out of Washtenaw County created guidelines, and he uses a computer that I have a copy of, and most lawyers and judges do. And this software program looks at the age, education, length of marriage, and income of the parties to provide an estimate of what alimony should be under the circumstances. It's important to understand, though, that creative application of the software can provide very different results. For example, Mr. Ross's software allows you to score a case by education or score a case by income. And if you score a case by education, you may get one result, or if you score the case by income, you may get another. In the same vein, altering the income tax deductions may provide very different and disparate results. So it isn't as easy as just purchasing the software, typing in your numbers and saying, well, here's what the guidelines say. Because how you enter the data is often very important. But remember, even having a guideline number isn't dispositive. It doesn't make a decision because it doesn't take a look at the needs of the parties and all of the other subjective factors that are required. Notwithstanding, when we mediate cases, and the majority of cases settle, every mediator has a copy of guidelines. Every judge in his or her chambers has a copy of guidelines, specifically Craig Ross's guidelines, and looks at them when making a determination as to an alimony award. There are also local guidelines. By way of example, Judge Lombard, who is a former judge out of Wayne County, had a rule of thirds, which still remains popular. Judge Lombard's guidelines, where you take 1/3 of the difference of the parties' incomes after subtracting any child support obligations, and the duration of the alimony would be for 1/3 of the length of the marriage. So if the difference of the parties' incomes was $33,000 after paying child support, 1/3 of that, well, there'd be an $11,000 a year alimony award. For how long? Well, if it's a 9-year marriage, for 3 years. Judge Lombard's rule of thirds. There's also a percentage difference of incomes approach. How does that work? Well, you say, okay, he makes X amount of money, she makes X amount of money. All right, let's take 10 to 15% of that and call that alimony per year. Certainly another formulaic approach. And in long-term marriages, I've had judges, specifically in Oakland County, say, you know what, in this 30-year marriage, we're going to equalize the parties' incomes until retirement kicks in. Well, it may make sense in very long-term marriages to do something like that. Now, of course, I just want to emphasize this notion that guidelines are simply guidelines. They are not dispositive. The court must examine the 14 factors. However, oftentimes, what the guidelines show is what is in the award or in the settlement agreement, so they should not be ignored. Let's spend a minute talking about the term of alimony. Remember, under Judge Lombard's rule, alimony was for 1/3 of the length of the marriage. That's pretty common in settling a case to have an alimony duration of approximately 1/3 of the length of the marriage. But alimony can be rehabilitative or permanent. Well, what is rehabilitative alimony? Well, it's exactly what it says. The idea is that it's temporary in nature. You may be trying to give an opportunity for somebody to become self-sufficient, to re-educate, or to return to the workforce. Whereas permanent spousal support is permanent. It's going to last, well, until it doesn't, until it's terminated. We'll talk about that in a moment, but it's long-term alimony in marriages, for example, when somebody doesn't have any marketable skills, or maybe his or her health prevent them from working. We'll examine the difference between the two a little bit further when we talk about modifiable versus non-modifiable alimony awards. Now, it's important to understand that a judge may order rehabilitative alimony after trial, for example, and say alimony will be awarded for a period of 3 years, but it will not be forever barred. A judge can't do that because if circumstances change, you can always come back to court. In settlement, though, we have a different answer. Now, when I first created this slideshow, I think back in 2010 or 11, this slide was very important. We talked about IRC 71 and IRC 215. Alimony awards were tax deductible to the individual paying alimony and taxable to the individual receiving alimony. And oftentimes we negotiated this tax effect in terms of exchanging property in lieu of alimony. However, as the slide says, after January 1st of 2019, that's no longer the case. because of the Tax Cuts and Jobs Act. When President Trump needed to recover some of the tax cuts, he took this money away from individuals who were receiving or paying alimony. The result is more money for the tax coffers, but less of a break for individuals paying or receiving alimony. That also involves cases where an award was entered prior to January 2019, but was modified, for example, in 2020 or thereafter. Those awards will no longer be taxable to the payee, the individual receiving money, or tax deductible to the payor, the individual paying alimony. Let's take a closer look at some negotiation strategies when you are trying to settle a case and you're trying to examine alimony. Well, one of the things you have to understand is that there's a difference between modifiable and non-modifiable alimony. And I wrote in this bottom here that there's a key learning. A judge cannot order non-modifiable alimony. Even rehabilitative alimony ordered by a judge is modifiable. Well, let me give you an example. Let's say that after a divorce trial, a judge orders that the wife shall pay husband 3 years of alimony to provide the husband an opportunity to re-enter the workforce. That is a modifiable award. In fact, after the expiration of 3 years, if that individual cannot obtain employment or circumstances have otherwise changed, he can return to court and ask for more alimony. Why? Because Michigan compiled laws provides 552.28 that alimony is always modifiable. But that does not mean you cannot agree to a non-modifiable award, and this is where the negotiation strategy comes into play. Michigan law provides, in the seminal case of Staple versus Staple, is that you can enter into a contract, and that contract is to waive the statutory right to modify alimony. So what does that mean? Well, maybe instead of a 3-year award at $1,000 a month, you'll say, I'm going to pay you 3 years at $800 a month, but I cannot modify it even if I lose my job. The notion of non-modifiability is a leverage point for a client to alter the terms of the award to his or her advantage, and competent and good lawyers use it. But it doesn't come without risk. Non-modifiable means it's non-modifiable. So oftentimes we have to counsel clients about that risk and in terms of calculating and estimating the reward. Let's take a closer look at some negotiation strategies. And I have them coming up on the screen here. I think number E, or letter E here, is probably the most important, creative lawyering. That is, what can we do to maximize or minimize a client's alimony exposure under the circumstances? Well, it depends if you're representing, of course, the primary wage earner or the dependent spouse. But some ways that we do that. If a client, for example, is more interested in cash flow, we'll first negotiate the lowest alimony award that we can, and then we'll offer property at a discount in lieu of alimony, or maybe the assumption of debt in lieu of paying alimony. And there's also this notion of present value and discounting prepayments. Well, what do I mean by that? Well, present value is the notion that $1 in your pocket now is worth more than $1 in the future. So if we negotiate an alimony award, and let's say that sum is $1,000 a month for 10 years, $120,000. Well, you wouldn't just give somebody $120,000 and pay that off. You would ask for a discount, and that is taking into account the present value of the money. You'd apply a discount rate. So maybe we'd offer $80,000 or whatever the case may be by negotiating an appropriate discount rate. Now, the Federal Reserve prints a discount rate, but that's for banks. What about in divorce cases? Can you get 3%? Can you get 5%? Can you get 6%? Well, a qualified lawyer can help you negotiate the best rate to minimize or maximize your payment. The idea here is that because the majority of cases settle, that when examining alimony, looking at the factors, the 14 factors, examining guidelines, and then creative negotiation can help you achieve your goals, whatever they may be. We've covered a lot of complicated topics in this webinar on alimony and spousal support in Michigan. It's inevitable that you're going to have questions. I want to invite you to call me personally, 248-399-3300. You can email me, or of course, visit our website, Findling Law or thedivorceguy.com. We're ready to help you, and I'm hopeful that you found some comfort in learning a little bit more about alimony and spousal support in Michigan. Thank you so much for your time if you've made it this far, and of course, we're ready to help you anytime you need it.